Hi, everyone. Thank you so much for joining us. We're going to wait another minute or two to make sure that everyone who wants to log in to our webinar today can do so and they don't miss any important content. So if you just bear with us for about another moment. Okay, let's go ahead and get started. First of all, thank you everybody for joining us today. I'm Annette Piniazic. I'm the Director of Grants and Major Gifts for Houston Area Parkinson's Society. And this is the third of our quarterly estate planning education webinars. And we're fortunate enough once again to have Kathleen Wiesenthal as our presenter, and she's an attorney with Kiever and Wiesenthal. Her practice focuses on probate, real estate, and estate planning. And we launched this series of estate planning webinars in response to requests from the community. So we will get started in just a sec. Kathleen today is going to be talking about legacy wealth planning, and she'll discuss steps that can be taken to protect assets while providing for one's family. Today's webinar is being recorded, and a link for it will be available on the HAPS.org website and also on the HAPS YouTube channel. And we have the first two webinars on there as well. And we've reserved some time for questions and answers after Kathleen's presentation. And you can always add your question for Kathleen at any time on the Q&A at the very bottom of your screen. And we'll answer them when we get to the end of Kathleen's presentation. So I am going to turn everything over to Kathleen, and thank you all again for joining us.
Good morning or good afternoon, everybody. It's so good that you're with us today. I'm very happy that there are some people out there who want to find out what they can do to prepare their estate plan to protect the legacy for their families, for their spouses, and maybe for generations to come. My topic is technically legacy wealth and how to preserve it. But I'm going to show you the estate planning way of legacy wealth. Obviously, there are two types. When you're thinking about legacy wealth, you're thinking about your financial planner, your IRAs, 401ks, your stocks and your portfolio that's going to help take care of you in your later years, and hopefully pass that on to your descendants also. If But in my case, I don't necessarily talk about your assets in terms of how much or how you're going to give it to your family, but what I can do is tell you about how to protect it and to get it to the people that you want to get it to. Our agenda today, I'm going to pull up my slideshow here. And our agenda today is discussing the wills, trusts, custodian payable on deaths, and we'll talk about that because some of you may not know what that means, transfer on death deeds, and ladybird deeds. Those last two items are how you can convey real property anywhere in the state of Texas. All right, so we are going to cover wills first because those are my favorite. A will can be extremely helpful to a comfortable and uh, comprehensive estate plan. The estate plan is to help take care of all aspects of your life and your assets. The will will most definitely help you move your assets to your loved ones. A will acts as your intention in writing of where you want all of your possessions to go, your assets, your possessions, your children, in case you have minor children. All of this will be considered when you um, go to read someone's will. You will find out exactly what they're going to have to do with regard to moving all the assets to the loved ones. The will has some benefits. It has a lot of benefits, if you ask me personally. I think they're wonderful and they make a huge difference in somebody's estate plan. It's not always the most happy thing to put together, but we can make it fun. And the drawbacks of not having or of having a will is that there is a cost associated with probating a will. The benefits are that all of your assets, every single thing you own, can be dispensed with when a will is probated. So you can put everything with the right language, and that's what an estate attorney does for you. The every item in a will can be dispensed with and moved and conveyed and gifted to all of your family members, depending on the characteristic of the asset itself. Keep in mind, I'm going to talk a lot about characteristic of assets. And that means that I don't care so much as an estate attorney, for instance, on what the value of an asset is, as long as it's not over the inheritance tax, which I think is 13.09. I've forgotten exactly what the inheritance tax is right now. But the whole idea is that I worry about the character of your assets so that we can make sure that we do the right thing in the will using the right language to make sure that your assets are going to go to the correct people with the right language in the will to convey it properly so that there's not going to be any hiccups on the way getting it to your beneficiaries. Contingency trusts, which is a trust that is for minor children, incapacitated persons, children or adults, or in some cases, it could be for spendthrifts. If you don't know what a spendthrift is, if you know anybody who cannot go um, without spending a lot of money every day, that's a spendthrift. If they have it, they'll spend it. There's ways to set up contingency trusts that will protect the hard-earned legacy you've put together from your family also. Contingency trusts are something that we'll go into a little bit more in a few more slides. Um, Also in a will, persons who would normally be considered the objects of your bounty. It's a legal term, it's an old case law term, and it means that anybody who would normally be someone who would inherit from you, your children, grandchildren, spouse, sometimes even parents, you can disinherit them if it's necessary in your will. And obviously, that would depend on the individual situation, the unique family situation for somebody preparing a will. We don't use nasty language in a will to say somebody's been disinherited. But we could put something very kind in that says that you're making no provisions for them because they are well taken care of, or that they are successful in their own right, or something like that. But you want to, if you're not going to give somebody that is the natural object of your bounty, like your children, you should mention it in your will and state that you're not giving them any assets. And it doesn't have to be a reason why. You could say, and they're familiar with the reasons. Maybe you've been giving them money ever since they were 18. So the idea is that you should mention them so they can't sue the estate later and say, oh, they forgot all about me. They must not have been in their right mind. This is addressing the issue that they would normally have inherited from you, but you specifically took them out of the will because you didn't feel that you needed to provide for them and you preferred to provide for other people. A will becomes a legal document when it's been entered into probate. So therefore, if you leave real property in a will, your house, your land, that will can act as a deed from the estate to the person who has, or the people who have inherited that land. There isn't necessarily a reason to do another deed unless there are some particular items you need to deal with in a deed. Sometimes title companies, when you go to sell a piece of property, may not be on the same page about this, but when you are dealing with a will that very specifically states either a legal description or a proper address for a piece of property, that can be used as a deed. If the address is only, 0 Sandlot Lane, that's not going to help. Okay, we have to have the state, county, perhaps, and well, actually, I prefer to use a county and a zip code. If you can also include a legal description. Those are the different ways that you can make sure to move your property with the benefit of having the will and that your executor doesn't have to do any extra work. Now let's talk about trusts for a minute. A lot of people ask me about trusts. Trusts used to be a thing. Everybody did one because there were tax saving benefits of having assets in a trust. There probably still are. I'm not a CPA and I'm not a tax attorney, and I'm also not a financial planner. But I do see that there are some reasons for setting up a trust for tax saving purposes. Your CPA or your financial planner, preferably your CPA, would be the best person to address that for you for your unique situation. So I've given you here 5 scenarios of when I think a trust is definitely called for. And the rest of the time, it depends on the unique facts of each case. So for instance, if you have any minor children, a trust is absolutely necessary because you can't give money to minor children. You can't just say, I'm leaving $500,000 to my grandson, who's 5, without leaving it in a trust. It doesn't have to already be set up. That's where the contingency trust comes in. The contingency is that the testator has passed away, there's a minor child involved who is under the age of 18, and there is it doesn't matter what amount, but there's an amount of money to be given to that child. Parents are not automatically the trustees for a child's property, especially when it comes to an estate. If you've got liquid funds, or let's say that the grandma leaves the house to the baby grandson, that can be done, but it goes into a trust and the trust has to manage that. And the parent most likely cannot be the trustee. They will have to find another trustee. There are exceptions to that, so don't panic if any parents are out there thinking that they can't manage it. But it's usually frowned upon because the parent is going to have a conflict of interest with their child for saving that money for that child's age of majority. Incapacitated children or adults, if you have any of those people in your family or in the loved ones that you're going to be leaving something to, it is very, very important to preserve government benefits for incapacitated children or adults. Government benefits, as you all might, even if you don't know it firsthand, you probably heard that government benefits are dependent upon the financial status of the individual receiving them. So if you have an incapacitated adult who's receiving Medicaid, for instance, this is just a for instance, there's lots of scenarios to go with this. If you have somebody that's needing Medicaid and they're on it, if you leave any money to them without putting it into a Medicaid approved trust, you are going to be having them, it's possible that they will be pushed out of Medicaid because they were going to have too many assets. So if you've got a situation where you've got incapacitated children or adults, you want to be very careful about leaving any money to them and maybe even set up trusts in other places to try to, and I say places, there's different characters of trust too. You can put money into a trust for that the government runs, an able trust, or if you've got, you may have a private trust to set it up. So for instance, if you've got um, something at Frost Bank and Frost Bank sets up a trust for your child or your grandchild, those are all ways to put the money that you have into a safe place with a trustee who is going to be on the ball with making sure that the trust is earning enough money for the incapacitated person. And then they will be sensitive to the fact that there are government benefits involved that we cannot lose. And so the trust will either dole out the money as necessary according to Medicaid guidelines. Now, that's just one scenario if there's Medicaid involved. There are different scenarios for everybody. And it's definitely something you want to talk with your estate planning attorney about to make sure that you are not leaving money to somebody that will uh, uh, reduce their benefits and or affect them negatively in any way. The spendthrift, again, I talked about that. If you have somebody who just cannot not spend their money, a spendthrift trust is legitimate to do. I have many parents who come in to talk to me about putting money into a trust for their child that if they left it all to them would be gone in a year. But what they want to do is give money maybe monthly, a monthly stipend, or they may just want to give it one check a year. They may not want them to get their money until they're 30, 35, 40, whatever a parent can dream up or a grandparent, we can make that happen in writing. And the idea is that the legacy you've worked so hard for doesn't get spent on a sports car in the first 6 months of them inheriting their money. So, not that sports cars are bad. It's just that you want to make sure that people are using the money for when they can't see any further than their nose for what their needs might be. You, as a parent, you're going to want to make sure that that's available for them. The next one is assets which produce income. Now, there maybe you will want to put some assets in a trust if you think that the income produced on those assets might be very helpful for your loved ones down the road. Maybe you don't want to give it to them outright so that they can reinvest it, which they could do if you left it to them outright. Or you might want to make sure that um, the income will be what they can live off of and perhaps leave the core principal of the money in the estate for emergencies. Most trusts will provide for health, education, maintenance, well-being, things like that, which includes maybe health insurance for a younger adult, college money for a child who's 18 or older. It may include their first car in a trust, so that they can drive around the campus at college where they're going. But it all depends on the individual and it depends on the rules that have been set forth in the trust and what the trustee is allowed to do, what power you give the trustee. Now, if you're talking about to preserve a legacy for a next generation, most likely a trust is a beautiful thing for that. In other words, you're not going to be giving the money outright free of trust to any one person who is the beneficiary of your estate. You can do this. Actually, you can even do this for several people. So, for instance, if you have a spendthrift son who can't keep any money in his pocket, you could set up a trust for him that has different rules than the trust for the legacy for the next generation. If you have another daughter who has three children, you might want to make sure that her money makes her life comfortable in that comes out of her trust, but that there's money, perhaps the principal is available for the children when they become of age, for grandchildren. So there's lots of different ways to do a trust, lots of different reasons to have one. Again, when it comes to tax saving benefits, you're going to have to get in touch with your CPA, because it really depends on the individual's a personal situation. Okay. If you have other questions about trusts, because there are, of course, a lot of questions, you will probably, excuse me, you will want to contact an estate planning attorney to have that conversation to see if that's going to be helpful to you. Now, keep in mind that any assets in a trust, if you take them out of the trust and move them, okay, let me back up a little bit. When you pass away, most trusts that I work with are what we call testamentary trusts. So they don't even become formed until the testator or the grantor, in this case, the deceased person, has passed away and their assets are moved to the trust in a legal fashion. Okay. So if the trust has not been funded ahead of time, you won't actually have a trust in place until someone passes away. When they've passed away, it will go into a trust, maybe in a family trust, or it could go into a trust of an individual person's name. And it can do that too. You can split it all up and have Johnny, Julie, and Jill all have a separate trust as your grandkids. Your daughter could have a separate trust, or it could be a family trust where it starts with your children and moves on down through your grandkids as time goes by. To preserve that for next generation, if you if you work in tandem with your CPA and with your estate planning attorney, you should be able to realize what will be a good plan for you and your assets that will work. Now, things change. Everybody's life changes. Your assets may change character. You may find you have a few more grandkids, or you might find that as your other children are growing up, the younger ones, that maybe you found they can't get their funds right away. You might want to treat it differently. Those are all things that can be worked with. The trust can be amended. Once a trust has been formed, it usually, unless you put that language in there, cannot be dissolved. The idea is that you're wanting your trustee to make sure this is still in place. Another thing to consider too is that you want to pick a trustee who's going to outlive you. Sometimes I recommend to people, especially when they're older adults, that they pick a trustee, a corporate trustee, or an institutional one, such as Cadence Bank or Texas Bank or something like that, so that they have an opportunity to work with a larger institution that will help them uh, put the money in safe places for their children. Um, there are there are fees, of course, involved, but also keep in mind that your trustee is allowed to ask for fees. So if you put a trustee in charge of the trust, they get to ask for up to 5% of the estate that they have dealt with. If there's $4 million and all they've done is hand out 20,000 a year to each beneficiary, that's not handling the whole estate. They're just unless they had to sit down and come up with very complex financial decisions about the estate and where to invest it. those are kinds of things that a trustee can charge money also. So if a trustee is a person or a corporate trustee, you're still in good form. The corporate trustee, you're going to need to ask their permission first. You can't just put down your favorite bank and just expect that to happen. We had a situation, I say we, my firm had a situation where a particular bank was listed and also had agreed and did a management agreement for minor children. And when the woman died, the bank said, we don't want to do it anymore. So they had to search like crazy, get the first bank to sign all these documents over because they had, once she died, they became the trustee. And so you want to really work with somebody that's going to be there for you when it comes time to deal with all of this. Let's see here. Speaking of custodians and people who are handling your money for you, um, there are different assets. These are some of the characteristics on the left side of your screen of assets that you can have that are held by custodians. And a custodian is anybody that you've signed a contract with, or even just a signature card with, to have them handle your money and to make sure that your money is held according to the law, according to your wishes, that you've got beneficiaries listed, that you've got the proper owners listed on each account, and so on. So checking and savings makes perfect sense. All your money is in the bank and they're taking care of it for you. They will allow you to write checks and they will allow you to make deposits. And there's an agreement that they're going to have with you regarding who are the owners of the account. We're going to get to that in just a second. Retirement accounts may be held with Fidelity or Merrill Lynch or something to that effect. Those are because they're held by a custodian and you do have a contract with them that says, yes, I will follow all the rules that you tell me these. And when they say we've updated our terms and conditions, when you sign that and approve it, then you are signing on to the fact that you're going to follow their rules, but they are still required to handle your money in a reasonable manner, to have fiduciary responsibility for your money. And that's why, again, it's a custodial account. CDs are a custodial account. You actually sign a contract with the bank or any kind of institution, credit union, and you are telling them that you want them to take this money and put it away for 3 years, and then you want to be able to have it paid back to you or to turn it back over again after the CD has matured. Again, custodial because somebody else is handling it for you, and they're guaranteeing you X amount in interest on that fund. Brokerage accounts, if they're not already retirement accounts, if you have brokerage accounts, you also have a contract with them. And the contract is that they're going to take your assets, your stocks, bonds, mutual funds, whatever it is you have, and they're going to grow them for you, hopefully, and that you will be uh, getting some kind of return from that. You want to have a benefit, obviously, for them holding your money, and that they will protect that brokerage account from fraud, from now they would probably beg to differ with me about that and say they don't have that kind of responsibility. But basically, you're dealing with them to be fair and have fiduciary responsibilities in order to make sure that your money is safe. Pensions and annuities, same thing. You may have received an annuity from your company or your pension from an old company you worked for, but yet they are held by a custodian, and those custodians are in charge of making sure that that money gets to you as it's been arranged or promised. And then you are going to have to um, make sure that you've got beneficiaries selected, and if not, we'll go over that too, if you don't have beneficiaries. The terminology that you're looking for in many cases when you have a custodial account is whether or not you're a joint tenant with rights of survivorship. If you are a married couple and you have a checking account that you both share, pay all the household expenses out of, your names are both on it, you both can sign checks, you both can deposit, you both can withdraw. That is most likely a joint tenant with rights of survivorship. It also may just be that your spouse is a joint signer, which is a different situation altogether. It could be that you're just a joint tenant on the account, but with no rights of survivorship. The bank, when one of you passes away, the bank is not going to be the one to determine who gets the money if it doesn't have the language with rights of survivorship. That language is important because that gives the bank the ability without liability to hand over the money to the joint tenant, the other tenant of the account. And that's pretty much, that will follow for all the other accounts too. If you get a chance to look at your signature cards with your banks, retirement accounts, CDs, whatever, look at those very carefully and see if that language is there. Now, what will happen if the language is not there is that when one of you passes, they will freeze the account, but only for the period of time it takes you to go and probate the estate, because they will want a court order. They are not just going to say, well, it says in the will, I get it. They will need a court order because a will is not a legal document until it's been entered into probate. Okay. And so they might freeze your accounts. It's very hard to talk a bank out of freezing an account during a time when you need it. You can go to a court and ask for an order to release X amount of funds to bury somebody, but the bank will take so long in considering all of that, that it's very likely that you will already have finished the probate by then. So keep in mind that all of these things are not meant to keep your money from you, although it seems like that, but you can make arrangements to make sure that this doesn't happen to you. Another way that you can get to make sure that a bank can't freeze your account is to have a payable on death individual or individuals. And so, for instance, if you have $300,000 in an account, you have 3 children. If you have payable on death to my 3 children, they will write a check from that account to all 3 children upon the proffering of a death certificate and perhaps a probate um, case number and things like that. But with a payable on death, you don't necessarily need to have the court order. The same thing with the joint tenant with rights of survivorship. It's very likely that 99% of the banking institutions or financial institutions are not going to require a court order. All you'll have to show is the death certificate, which obviously makes perfect sense. And it's a lovely way to make sure that your asset is wide open and ready to be used to pay for your funeral, to pay for expenses. Once you've died, the bills don't stop coming. And it could pay for just regular living expenses. If the person who has died is the main breadwinner, that's going to be really hard on a spouse. So you want to make sure that that's taken care of. And you just have to go visit your bank or your credit union and make sure that's all set up. A transfer on death is something you can do with brokerage accounts or retirement accounts. When you have an account that's not liquid, you can do a transfer on death. So, for instance, if you're the surviving spouse and you have 3 children, and you want all 3 of the children to be able to get this retirement account, but you don't necessarily want them to have, you don't want to make them have the whole account and then divvy it up themselves. You can actually set it up as a transfer on death. Well, I guess you could do it as a transfer on death if it was all 3 of them too. But the idea is that if you've got stocks, bonds, mutual funds, etc., those aren't liquid. So it's not likely that that custodian is going to be able to just cut checks. you're going to have to transfer those assets to the children, and then the custodian will help them decide where they want or how they want to receive that money. Do they want to cash out all the stocks that they will own, or do they want to um, just keep the stocks in their own account and open up an account for themselves, which a lot of people do. Um, so those are handled a little differently. And just remember that term, transfer on death. That's for things that aren't liquid assets and they aren't just cash. Having a beneficiary for an account, or beneficiaries plural, is very important. Also, if you haven't used any of this other language, at least make sure you've got beneficiaries selected. If you and your spouse have listed each other and no one else, it might be a problem. It's not a problem. It's not that nobody will get the money. It's just that you'll have to wait until probate is finished in order to be able to get that money, because that financial institution is not giving it to anybody until they have a named beneficiary or a named heir. And that's what if you don't have a will, or if you do have a will, and you've got heirs involved, or you've got just beneficiaries involved, or family members, descendants, those will be found to be the beneficiaries once you have a court order telling the bank, these are all the heirs, these are the people entitled by law to receive that money. Now, the only problem with that is if you haven't designated a beneficiary, or a transfer on death, or a payable on death, and let's say your husband has 3 kids by another relationship and you have 3, um, then when your husband dies, if he doesn't have beneficiaries selected on those particular accounts, it goes into his estate. If this has been a separate property account of his, for instance, if it's a 401k or an IRA, those are separate property. They don't belong to the spouse as community property in most cases. I mean, there may be some circumstances that they might, but then what will happen is, oh, let's say, for instance, you're the wife, you have 3 children by a prior relationship. Your husband has 3 adult children by a prior relationship also. He didn't list a beneficiary on his 401k. Because it's separate property, that 401k is going to his kids. So on one hand, if he didn't care if it went to his kids, that's a good thing. It won't go there until you've probated the estate, though. And um, I see, I'm trying to think if there's any other extenuating circumstances, and there always are different circumstances for each fact. But the beneficiaries could change or surprise you if the proper paperwork isn't done at these custodians. The if you and your husband have an agreement that you're going to get all of his assets, he's got to put that in writing. Or the wife, even if they both, the spouses have to put that in writing. It has to be in a will, or it has to be designated at these custodians. Now, let me tell you something else. You've been hearing me use the word contract with these custodians. The third-party custodians have contracts with you. Contracts in Texas are sacred. If somebody has a contract saying, I want to give all my money to the guy on the corner that sells tacos, okay? And your will says, I want it to go to my wife. If that retirement, let's say it's a retirement account, if that person dies without changing their will, or without changing their beneficiaries on their particular account that they have, the guy on the corner who sells tacos is going to get the asset because the contract rules. The only other time where you're not going to have that happen is if you have contractual wills. And that's a different issue. I didn't even put that in this presentation today. But the idea is that the contract will always rule because contracts are sacred. If you've made a contract with somebody to give, and the somebody is the custodian. You've told Merrill Lynch that all my money is going to go to the taco truck driver. When you pass away, if you haven't mentioned anything else in your will about this, it's going to go to the taco truck driver. There is not a situation, except for undue influence or, incapacity, where a will is going to um, outwork the custodial agreement. Custodial agreement will rule no matter what. So you got to be careful that all of your custodians have your wishes in their files, and you probably want to check them every couple of years and make sure that they haven't lost your paperwork or have accidentally, maybe you forgot, you put your ex-wife on one of your policies and forgot to take her off, things like that. There's some um, terminology here that I wanted you to be aware of too. A lot of people ask me, what's the difference between a beneficiary, executor, administrator, trustee? And I can give you very good explanations that are very simple. A beneficiary is whoever you're giving an asset to. And usually that's in a will because they're actually receiving that from you after your death. An executor is who you appoint to execute your will. That person will do what that will has asked them to do, moving assets to beneficiaries or moving assets to heirs. And that executor only has a finite job. They shouldn't be doing it forever. It may take a year or two, and sometimes three. But the idea is that executor is going to make sure that all of the assets move out of the estate, which is where all the assets are when you first pass away, to the proper place, either to the beneficiary, to a trust, and wherever that may be going. If you have a charitable organization that you've mentioned in your will, you will want to, so for instance, if you want to leave money to HAPS, to the Houston Area Parkinson's Society, you would make sure that that's in the will. The executor will have complete instructions, if the attorney's doing their job, complete instructions on how to give it to HAPS and how the EIN number for HAPS, things like that. That can all be done within the will. So the executor has his instructions, his or her instructions. It's very nice to be able to give those instructions to your executor and maybe even discuss it with them and make sure your executor understands what is expected of them. An executor is when you have a will and you actually appoint somebody in your will to say, I want this person to be my executor. An administrator is when you don't have a will and or there are no longer any executors alive to serve as an executor in a will, and there's no other person named in a will. Then the administrator takes over as a person who the beneficiaries and or the heirs agree to let that person take over the administration of the estate. They will be doing a lot of what an executor would do, but the administrator is going to do it with a little bit less power. So if you can, and I encourage people to do this, make sure you've got successor executors selected or give your executor the power to appoint an administrator. Trustees are the people who take care of any money that has gone into trust for whatever reason. And those trustees have a fiduciary responsibility to the estate. They don't necessarily have a fiduciary responsibility to the beneficiaries. However, they may, if there's any wrongdoing of their own person, like if I take over a trust and I just don't do my job, I just blow it off. I do not care. I don't change any money around when things are bad in the stock market, things like that. I could be liable individually for being, mismanaging the trust. However, as the trustee in general, that trustee does not owe beneficiaries a duty. All right. let's see, transfer on death deed. I've only got a few minutes left. Transfer on death deed, you may have heard about, is chapter 114 of the Texas State Code that allows somebody to, again, let me use me as an example. I want to give my property to my daughter upon my death. I'll put it in the will, but what if I've moved and I've got a new property and I've got a townhome or something like this? Or what if I just want to make sure my nephews don't get the property, if by any other circumstance, like having heirs, things like that. I will leave the property in a transfer on death deed to my daughter. That will be filed, that document, it's about 2 pages long, sometimes three. I will put that document into the Harris County, because my property is in Harris County. We'll put that into the Harris County real property records. It does not take effect until I have died. So at the moment of my death, my daughter has legal rights and equitable rights to the property. You must do an affidavit of death after somebody has passed away when they have a TOD on file. Most attorneys and their families, the families of people who have passed, should probably check to see if there's a TOD on file for property before they go and probate the estate under a misimpression about who owns the property. And a TOD can avoid a MERP claim against the homestead. A homestead is sacred under Medicaid. That's MERP is Medicaid Estate Recovery Program. Those homestead you are allowed to have when you've passed away. However, the recovery program can go after an asset after someone has died if they find it's necessary to repay the program. A TOD avoids that because at the time of their death, this property is no longer theirs. And what the Medicaid program is going to look for is what assets were in the estate at death. Well, at death, the house wasn't there anymore. So that will avoid a MERP claim. It may not be created by a power of attorney. You can't give somebody else's property away by a power of attorney, no matter how hard you try. So if you've got somebody who's incapacitated and they want to try to do a TOD, you're probably not going to be able to do that. And it would be a very bad idea to try it because all you're going to do is open the estate up to litigation. All right, let's see here. Ladybird deeds are slightly different than a transfer on death deed. What you're doing with a ladybird deed is I'm giving my property to my daughter, but I want to live there and have complete unilateral opportunity to be able to pull that back from her if I need to. Like, let's say I need to sell the house and I need the money to pay for my care. Or if I need to rescind it because she and I had a big fight. Those I laugh, but that is a lot of the reasons people do rescind them. That too avoids a MERP claim against a homestead. And why that does that is because the enhanced life estate that you keep, in other words, I keep a life estate that allows me to live there for the rest of my life unless I abandon the property. And it also allows me, I have to be responsible for the maintenance and the taxes. And it's not something that you take lightly. It isn't just that you get to park yourself there and not pay anything. It may be created by a durable power of attorney agent, preferably if it expressly is authorized by the power of attorney. So if anybody anticipates that they're going to want to have to do that, or if they decide to do a ladybird deed, I always recommend that we redo their power of attorney so that it includes that right, so nobody can express any doubts about whether or not it was appropriate to do. Okay, so please make sure that some of the things that I really want you to remember, because I know I've thrown a lot of information at you, is please note the character of an asset. Is it liquid assets, funds? Is it stocks and bonds? Is it a house? Is it a car? Is it a trust? You may already own a trust that you have to consider when you do your estate plan. Determine if there's a custodian of the asset And what are their rules to transfer? So you're going to have discussions with your custodians to find out what kind of rules they have for transferring. So for instance, there's one, I don't know the name of the custodian off the top of my head, but they would not let my client select more than one beneficiary. If that's unacceptable to you, move your money. But that's very troublesome because if something happens to your primary beneficiary, you're right back where you started before a will, and it goes into your estate, and you have to probate it, and they have to wait for a court order, etc. Um, who do you want to have that asset? Do you want your children, your grandchildren? Do you want a very good friend? Do you want a charitable organization? Do you want whatever your wishes are on who or what has that asset? And make sure that's pretty clear in your mind before you start to do an estate plan. When do you want them to have it is also very important. Most people say, oh, just let them have it when I'm gone. Doesn't matter. But if you've decided that you think it would be better served, your family would be better served if you doled it out a little bit each year, maybe till they're age 45 or something like that. You can do that. You can do whatever you dream, an estate attorney can put that together for you. And how do you want them to receive it? Do you want them to receive it in monthly or yearly, or quarterly amounts? Do you want them to receive it all at once when you pass away? Do you want them to receive it like if you leave a house, do you want them to have the house and keep the house? Or do you want them to sell the house and keep the cash? That kind of thing. And let me see. I think that's it then. If we have any questions, I'm very excited to answer any that you might have. I'm sorry I didn't leave much time.
No, thank you as always, Kathleen. You always give us a lot of really great information.
Thank you.
And we do have some questions. We have some time to be able to address them. Somebody has asked if they've named their wife as the executor of their estate, but she now has cognitive issues. Does she need to update her will, or does their son automatically become the executor, even if he is not named as such?
No, no, the son would not automatically, nobody automatically becomes an executor. Either the testator in a will has to update their will, which if they've already have cognitive issues, that may not be possible. So you're already facing the fact that you may have to move forward as if you didn't have an executor. But check the will to make sure that the executor didn't have any power to name somebody else. But nobody automatically becomes the new executor. That has to be a judge's decision.
Yeah, and just to make sure I said it correctly,
Uh-huh.
the person who posed the question said that their spouse is the one who has the cognitive issue. So,
Oh,
yeah,
okay. Well, the spouse cannot make a new will. And if the spouse is the one that they put as the executor, the spouse who does not have cognitive issues should be the one changing their will to make sure that their executor has a successor listed. And if they've got the spouse who has cognitive issues listed, that's not going to fly. That's not going to work, obviously. Also, something I forgot to mention is if you have a spouse or a child that you want to have as an executor or a trustee, if they've been convicted of a felony, they can't. They won't qualify. So be aware of that when you're setting up your trustees or executors.
okay. So the person you think should automatically have their will updated since their
Yes, ma'am.
spouse is now cognitively impaired.
Yes, ma'am.
Kind of on the same note, my spouse has dementia. Do I need to set up a trust to take care of them if I should die first?
You can actually do one of the contingency trusts that I talked about that are put directly into a will. You don't have to set up a separate trust. But it depends on their disability too. You may have to set up something depending on how much money you have to put that away into a third party or a custodial account with a large, bank or something like that. But yes, you will. it is very important for you to make sure there's some kind of a trust, a contingency or setup or something for that person so that if when you're gone, if they're going to require Medicaid to survive, you're going to want to put some money aside for them and not interfere with their Medicaid.
All right. Can real property be passed without a probate case?
Yes, it can. And I'm probably remiss in not explaining that better. A transfer on death deed can move real property without a will and without probate. I have some people that that's all they have to do is file that transfer on death deed and they don't have anything else in their estate. Or they have, because they have joint tenants with rights of survivorship on a checking account. So they don't have to probate the checking account because it's already belonging to someone else. So and those are the things that you would talk about with an estate planner. But yes, you can definitely transfer property in lots of different ways. I haven't even mentioned them all. So you wouldn't even have to go through probate if that were necessary.
Okay. How should the child of elderly parents handle their estate planning? What documents do the parents need to get in order?
I would suggest they at least have a good will. And I say a good will, not an online Zoom will. Okay. Just saying. But a good will with a planner and powers of attorney would be really, really helpful if they have those. Because if their parents lose capacity, and we're all going to live to an age that we would not have ever expected, 50 years ago. And if there's incapacity that goes with that, you don't want their assets to be messed around. And, you know, having powers of attorney can also help prevent fraud. And so you really want to make sure your parents have some kind of powers of attorney if they're willing to do it.
Okay, and just to remind people that you did an earlier webinar that was over powers of attorney, which is
Yes.
on haps.org or also on our YouTube channel. So people could always refer back to that. Even though it's recorded, I'm sure they'll find interesting information.
Yeah.
Should you put what you want done with your remains in your will?
Yes, you can. You can. There's also a separate document, actually, two different kinds of separate documents. It depends what you want. If you want to be composted or cremated or buried in your grandma's plot in Michigan somewhere, that kind of thing. Those are all something you can put in your will. And but actually, there's another document that's more immediate because when you pass away, you kind of have to make a decision right then of what you're going to be doing. So if somebody has already prepared, it's called an appointment for disposition of remains. If somebody has already prepared one of those, the deceased person can declare certain agents to be in charge of that. And that agent hopefully already knows they're in charge of it so they can jump to it when somebody passes.
Okay, we still have a couple of minutes left. Um, if we wanted to leave money to HAPS, is it best to leave a percentage or a firm dollar amount? And what is the better way to set it forth in the will?
Setting it up in the will is easy. That's just a specific bequest that we would add into the will. It's part of the sections of a will dispersing your assets. My own opinion, and you can do this any way you want, my own opinion is dollar amounts are much easier. Because if you put percentages, the executor is going to have to wait till they accumulate the entire estate before they can figure out what amount that percentage will equal to. And even then it could change. And so my own suggestion is when somebody leaves a charitable donation that they put a dollar amount and they can put contingencies in there of, and if there's any money left, give it all to HAPS or, but the idea is that you want to make it as easy as possible for your executor.
Okay. This person is asking about they had a will formatted in Tennessee 8 years ago, and now they've moved to Texas. Do they need to redraft the will?
That would really require a review. I'm not familiar with Tennessee wills. I haven't ever seen a Tennessee will. Lots of California and Florida wills, but nothing in Tennessee. Wills are funny creatures because they are usually written under the terminology and the laws of the state they were written in. So, as an example, I had somebody came in with a California will, and it said, all trusts will be set up under the laws of California trusts. Yeah, nobody knows what that means. So they're like, I don't know if I want to do that. And if you're all the way in Texas, do you really want California telling you what to do with that trust? And you have to do that because that's what's in the will. So my suggestion would be is to have it reviewed, and it might be necessary for you to redo the will for the state you ended up living in.
Okay, and someone else is asking if you could explain again what an executor is.
Of course, an executor, in a very short sentence, executes the will, executes the wishes of the will. They have a temporary job in most cases. It's finite. It doesn't go on forever. Like a trustees can go on forever as long as the money holds out. But an executor, their job is to make sure that the assets are given to the beneficiaries as they've been set out, that the debts are paid of the estate, and that all of the legal necessities are taken care of so that the will has the legal effect it's supposed to. So, and that's made it probably no clearer at all, I'm sure. But that again, your probate attorney is the one who really comes on board with that. Your attorney should be taking you through the process and making sure that that will is foolproof.
Okay, one last question. We're
Mhm.
already one moment over, but we could go a little bit more. If someone did their will years ago, let's say 10 years ago, and
Mhm.
nothing within their circumstances has changed, do you recommend that they get an updated or redone will?
I don't find that that's necessary. I just probated a will for a client that was written in 1967 and it was perfectly fine. As long as it has all of the requisite legal um, legal additions to the will. I'm trying to think of what the term would be, but as long as it's self-proved, if it's signed by two witnesses, if it's been notarized, and that the witnesses sign in front of each other, or at least state that they do, and that the will itself dispenses with most of their estate or all of their estate if possible. Sometimes there are things that are left out, but that's nobody's fault.
Okay, well, I think it's, as I said, it's a little past our time, but I just wanted to let everyone know that Kathleen's going to do our last quarterly webinar, which will be over probate, and she'll be discussing what probate is and its ins and its outs. And that's going to be on Friday, July the 11th from noon to 1 o'clock. Again, thank you all so much for tuning in, and thank you so much, Kathleen,
My
for
pleasure.
lending your knowledge and your expertise to all of us. So thanks, everyone. Hope everyone has a great rest of their day. Bye.
Bye.